client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we specialize in intellectual property, including patents, trademarks, and copyrights, as well as elder law. You can check us out online by visiting our website at oltmanpatent.com. That's oltmanpatent.com. You can also view all episodes of this show on our website. I'd like to thank all of our listeners, including those of you tuning in on the AM dial, as well as those watching online. If you have a question, comment, or story that you would like to share on the air, please feel free to call us toll-free at 888-565-1470. Once again, that toll-free number is 888-565-1470. We welcome your calls. I have a special guest in studio this evening. His name is Scott Zappolo. Scott and I go back quite a few years. He was my professor when I was an undergraduate over at Florida Atlantic University. And he's joined us this evening. He's a very experienced trial lawyer. He practices in a number of areas of law, but this evening we're going to be discussing false imprisonment. And he has tried a number of cases involving false imprisonment. And Scott, thank you so much for joining us this evening.
You're very welcome. Happy to be here.
Great. So if you might introduce to our listeners, what is a claim for false imprisonment, and when would a client come to you with a situation like this?
Well, hopefully clients don't need to come to me with a true claim of false imprisonment that is something that would arise like you see in a movie where someone's been tied up or locked in a room somewhere. Traditionally, false imprisonment claims that are brought in the state of Florida revolve around law enforcement acts, or more particularly quasi-law enforcement acts, which is a bit more popular. For example, someone was in a store, and whether they were actually guilty of shoplifting or whether they made a mistake and someone accused them of shoplifting, they might be detained by store personnel, typically referred to as loss prevention officers, and they are detained at a time when they'd prefer to go. And if a reasonable person feels that they are detained, typically they're probably detained. And that would be a situation where they could have a claim of false imprisonment.
Now, just as a background, false imprisonment is something that you can sue someone for. It's a tort. It's a cause of action. And it's something that involves restraining you or detaining a person. Now, there's something that we call shopkeeper's privilege, which is a store can detain somebody for the limited purpose of retrieving goods that may have been stolen or shoplifted. But there are limits on that. And if you could tell us a little bit about that.
There are limits on that. The shopkeeper's privilege is found within Florida Statute 812.015. And that's a statute that was enacted to protect shopkeepers, merchants in the state of Florida from those who would shoplift. And it says in its simplest terms, a shopkeeper, its employee, or a law enforcement officer can detain someone reasonably for a reasonable amount of time in order to recover their goods, so long as they have probable cause to believe that by detaining the person they can recover their goods. And here's the most important part: the police are immediately called to the scene. And it's very interesting because a lot of people don't realize that the police can be your savior in some of these situations. So you actually do want the police to come to the scene, and you should ask that the police be immediately called to the scene as is required by the statute.
So if let's say that you're in a store, and this has happened to a number of people that I know, they've eaten some produce or something, or they've sampled some edible material, and then somebody stops them and said, well, we saw you ate a peach or something like that, you have to pay for it. Or if you try to go out to your car, they say, well, give me your driver's license. Have you seen, in a situation like that, they can't do that because they can't possibly retrieve the goods. The goods have already been consumed.
Well, of course, they're going to stop you no matter what, and you can't control their actions. You can control, however, what you do. Under circumstances such as that, of course, the best course of action is not to eat the produce before you pay for it, et cetera. And so I always tell people, of course, your best course of action is not to be in a situation where you can be accused of having broken the law. But if you find yourself in an unfortunate situation where you may have inadvertently sampled a grape or something, and the shopkeeper or their loss prevention personnel ask you to stop and do physically detain you, they will physically detain you. It's best not to, certainly not to get into a physical altercation with them. Understand that even though they might suggest that they're going to be your friend, they typically have the attitude that they can lie to you, and a lot of people don't realize that. They will lie to you and say, if you give us back the goods, we won't call the police. And then you give them the goods or what have you, and then you find yourself in an unfortunate situation where the police have already been called. There are a number of establishments, we'll call them big box stores, that will ask you to fill out a bunch of paperwork. And they will explain very carefully the law as they see it. Unfortunately, I found that under many circumstances, the law as they see it is not the law as you or I might see it, because they're utilizing the law in a way that I believe is inappropriate. They are using it to try and capitalize on these situations and use it for a profit center as opposed to what the law was really designed for.
The law, of course, being designed to retrieve stolen property or property that would be stolen. And they're doing it in order to get the person to agree to pay something that's excessive. That's basically what happens, right?
Exactly. But here's what they do is they use Florida Statute 772.11, which is the Florida Civil Remedy for Theft or Exploitation statute, which basically says if someone does something and takes something of yours, say a neighbor's child comes into your driveway and takes your child's bike, and they won't give it back. Rather than having to go through the court system and try to get remuneration through the criminal court system, you can go ahead and you can send them a letter pursuant to that statute that gives them 30 days to give you 3 times the value of your goods or $200, whichever is greater. And if they don't, then you have a right to sue them in court. And if you prove by a certain standard that the person has actually stolen your goods, you can get your attorney's fees paid as well. And that's a very good statute for people that follow it, follow the letter of law, and give people that 30 days to consider. That person who's accused of theft might want to go out and seek an attorney's advice on this. The problem is some of these big box merchant stores and their agents are telling people, you need to make the decision right now. Go ahead and sign paperwork that says you're going to give us $200. And I've had a case where I've actually had people testify that if someone steals a 25-cent pack of gum, they try to get as much as they can out of the person. And it was very interesting. There was a judge that intervened, and he said, well, wait a minute. If I had stolen something, how much would you get? $200? And the person said, oh, sure. And then he said, well, more than that? He said, as much as I could get. And they do, and they use various techniques in order to get you to sign paperwork right there on the spot under basically threat of police intervention to pay them an enhanced amount of money that you probably don't owe. And it's very unfortunate, but people sign this paperwork, and then they find themselves in a position where they use the very paperwork that they've signed. It's being used against them for having the police actually arrest them.
So this brings up a point, which is that it's not a crime to lie, and they can lie to you and say that, you know, they're not going to call the cops if you sign this paperwork, and then they can call the cops, and they're perfectly able to do that. They can lie to you as much as they want.
Well, that's an interesting thing to look at, and here's the way it works. Most people can lie to you, and it's not a quote-unquote crime, and most people don't realize that the police are allowed to lie to you in order to get you to confess and things like that. These loss prevention officers feel that they can lie to you, but I draw a very distinct line in the sand on that. If they lie to you in order to induce you to sign something that has monetary value, they have then fraudulently induced you to sign a paper or given you money. If they tell you sign this paperwork or else the police are going to come and arrest you. But if you sign the paperwork, you won't be arrested. I view that as extortion. And so it's all these cases are very fact specific, but it's clear to me that guilty or innocent, you still have rights. And unfortunately, these loss prevention officers and the store employees are very well versed at, let's just say, persuading you to sign over very precious rights that you have, and then use your signature on documents and your attempts to work things out amicably against you for criminal prosecution. There have been a number of cases that I've come across where individuals have done all that they could, thinking that they were doing the right thing, even though they may have initially made a mistake. And the problem is exacerbated by the use of, or what I would deem the misuse of, this civil theft statute.
So what should you do if you're encountered by a loss mitigation officer and you are detained? Should you comply with them? Should you leave? What should you do?
Well, here's the situation. If you've done nothing wrong, obviously you need not comply with a complete stranger coming up to you, asking you to step into a room, etc. I found it very interesting that a lot of these big box stores have very specific rooms that they will take you to where there is no video. And I've had testimony from managers saying they take you in a room where there's no video so that no one can say what went on. I encourage people not to go into a room. They will say, why don't you come into our room so that you won't be embarrassed? Well, I'd rather you go ahead and stay right out in the open where there are other people there, stand right by some registers or something where you think you're going to be under video surveillance while they're there. And you can talk to them, but I encourage people to understand what's going on. They are trying to get you to admit to something, whether you've done it or not. They are trying to frequently get you to pay for something that you probably don't owe. My first advice is always don't make the mistake of committing a theft or anything like that. If you find yourself falsely accused, stand up for yourself. I've had a number of cases where individuals were falsely accused, but in order to just get along with their day or something like that, they will acknowledge and agree to sign some paperwork. And rather than have the police called, who wouldn't just give you $50? Well, if you've done nothing wrong, you certainly shouldn't be giving anyone any money. And unfortunately, if you find yourself in that situation, I encourage you to stay out in the open, ask that the police be immediately called.
And don't flee, because if you flee, that can be used as evidence of guilt.
Flight is absolutely something that the police look at and consider evidence of guilt. And if you've done nothing wrong, you have no reason to flee. And you have a delicate balancing act there. What if you're late for your daughter's wedding and someone says, we're going to detain you? They have a right to detain you if they have probable cause to believe that they can recover their goods. And so you have a delicate balancing act there. I do not recommend that people flee. I recommend that people whip out their own cell phone and call the police themselves and ask for the police to be promptly brought to the scene, because if you have a problem, the police should be able to sort it out pretty quickly.
Well, this has been a very interesting discussion. We're going to take a short break to hear from our sponsors, and then we'll be back with Scott Zappolo. Stay tuned.
This program is brought to you by Fresh Start Tax. Fresh Start Tax offers a full range of tax and accounting services, including tax return preparation and bookkeeping, as well as back taxes, wage garnishments, unfiled returns, or any other tax-related concern. Our dedicated team of tax attorneys, CPAs, and former IRS agents offer over 60 years of professional tax experience. For a free consultation, call 866-700-1040. That's 866-700-1040. You can also visit us on the web at freshstarttax.com. This program is brought to you by the law firm of Altman, Flynn, and Kubler. Our law firm specializes in elder law and intellectual property, including patents, trademarks, and copyrights. If you would like to patent your idea, please contact our Fort Lauderdale office for a free consultation. We offer elder law services, including estate planning, long-term care planning, and preparation of healthcare documents. We strive to plan for your future needs while allowing you to retain as much dignity and independence as possible. To find out more or to make an appointment, call 954-563-4600. 954-563-4814. That's 954-563-4814. Or visit us online at oltmanpatent.com. That's OLTMANPATENT.com. Spokesperson, not an attorney. You're listening to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, back to Talk Legal with Jeff Van Treese.
And we're back. My guest this evening is Scott Zappolo. He's an attorney in Palm Beach Gardens, and we've been discussing false imprisonment. So, Scott, we were talking about loss mitigation companies and how they get people to pay more in the event that they are detained for shoplifting than they really should be responsible for paying. And it's amazing how this has become a huge profit center. And in fact, some loss mitigation companies, as well as even some attorneys that represent them, use electronic means of payment like PayPal and that sort of thing. If you could tell us a little bit about that.
They do. What happens, what listeners can expect if they find themselves in this unfortunate situation is they will be approached by the loss prevention officer. They will typically be escorted into a room. They will then be told, we know that you stole, or they will suggest to you that there was a mistake made. And most people are much more likely to acknowledge a mistake rather than an outright theft. And perhaps there really was a legitimate mistake. They will then advise you that the law is that they are entitled to 3 times the value of the goods stolen, or $200, whichever is greater. And sometimes they even present you with a copy of the 772.11 statute. The problem is they don't always provide you with the entire copy of the statute. And so they say, look, that's the law. Now, we want to be your friend. We don't want you to go to jail. Why don't you go ahead and give us a statement? And they'll give you a statement form, and they will actually verbatim tell you what to write. And people do write, and they say nice things like, this was an accident. I'll never do it again. I apologize. I'm sorry. And they use a wonderful phrase, I'm sorry for any loss that I caused, because in the industry, a loss is a soft code word for theft. And what they'll do is they'll have you sign a whole bunch of paper, and then they'll say, before you can go, here, we need you to sign this promissory note. And there are a number of companies that will have people sign promissory notes on the spot. And as I said before, that is not the way the statute is written. The statute is written so that they're allowed to send you a letter that asks for this, asks for payment, and it gives you 30 days to comply. Now, what happens is some of the other big box stores and their loss prevention department actually have law firms that send out letters. I'm amazed at how often the letters misstate how much you should have to pay. And the average person, and they even suggest that you will be prosecuted if you don't pay. The reality of it is the civil recovery process and the criminal process go on 2 different tracks, okay? By paying a civil recovery, it's not going to keep you from being arrested. And they'll tell you that in a room. If you sign this paperwork, then the police don't have to be involved. Remember, they think they can lie to you. And so you sign the paperwork, and then 2 minutes later, you step out the door, and there's a police officer there to arrest you. And what's the police officer to think? You just signed paperwork agreeing to pay them back.
That's a confession.
Exactly. In their eyes, it's a confession, and you're going to be handcuffed and taken to jail. The other thing that's very interesting about this is the statute is designed so that people can recover their goods. In this instance, in most instances I see, the store has already recovered its goods because they stop you right outside the door, or even before you go out the door, after you've passed points of sale typically, and they will recover their goods immediately. Now, there's some debate as to whether or not they've actually suffered a loss, because technically they didn't have that product on the shelf for the 3 minutes or 5 minutes between the time you picked it up and they recovered it from you. But in my opinion, that it's a little bit harsh reading that they've been damaged by virtue of the fact that you took something and they recovered it minutes later and put it right back on the shelf for sale. But nevertheless, they're asking you for 3 times the value of that product. They'll also ask you for attorney's fees, et cetera. And some of these companies these law firms that will send the letters actually have websites where you can go on and pay by credit card or even by PayPal. And most people think, well, I'll just go ahead and get rid of this and handle it. Even though they're asking you for a little bit more money than you thought they should be entitled to ask you for, most people comply because, hey, I'd rather just move along. I'm embarrassed by the whole situation. But I always urge people to remember, just because you made a mistake doesn't mean that they're allowed to trample your rights.
And there was one story that you told me that I found to be astonishing, which was you were looking at one of these signed statements and you noticed there were some brownish marks on it. If you could tell me a little bit about that.
Sure. I've seen some real horror stories with these situations. One involved a photocopy of an alleged confession that was dictated by a loss prevention officer, and I got a very bad copy, and so I asked the other side to produce the original at a deposition, and when they produced the original at the deposition, it had very dark brown smudges all over it. And finally I asked the witness, what are all these brown smudges? Were they on this when you wrote the document? And he said very clearly, no, that's my blood. And I couldn't believe it. I said, oh, what are you talking about? He said, well, I was so nervous because they kept on telling me I was going to go to jail. I started biting my fingers, and my fingers were bleeding. And I asked them, can I have some paper towels to wipe the blood off my fingertips? And they kept telling me, we'll give you paper towels after you've finished writing your statement. To me, that just suggests the nature and the mindset of these the people that are engaged in these encounters. They are definitely there to control your mindset, control your acts, and quite frankly, if you have a right to leave and you want to leave and they don't, you have been falsely imprisoned.
Now, do they treat people differently? And we're referring to these loss mitigation specialists. Do they treat people differently if they're younger versus older? For example, if somebody has an intellectual disability, they might not understand the content of what they're signing. These issues probably also come up.
Unfortunately, that's very true. They do, and they seem to take advantage where they can take advantage. And if you have someone who's a younger individual, they will certainly put the fear of God in them, so to speak, that the individual is going to have a criminal record. You don't want to have a criminal record. You don't want your parents to find out.
You're worried about getting into college?
Exactly. All those things. Anything is fair game once you step in that room. And that's why I encourage people, do not go anywhere into a room. If they're going to detain you, they need to detain you right out in the open. And if the police don't get there, you call the police yourself, because the police can save you from a very unfortunate and very uncomfortable incident, even if you're guilty, believe it or not.
Now, of course, there's going to be cameras in a lot of these places, and certainly, especially if you're innocent, you're going to want that tape to prove that you're innocent if you're going to bring an action for false imprisonment. Now, what happens if that tape is destroyed?
Well, first of all, it's very interesting that you bring up the tape, because it is important that you get any evidence that you can as quickly as possible. So it's very important that you do contact a lawyer as quickly as possible, even if you are embarrassed about the situation. You do want to talk with someone who's been around the block, so to speak, and can advise you properly, because they'll get letters out immediately telling the store to preserve that tape and that evidence. And unfortunately, it's not always like CSI. We don't get the perfect video, et cetera, but we do want as much videotape as possible if it is there. And unfortunately, sometimes these tapes go missing. And of course, there is law that provides that if someone destroys evidence in a case, depending on where you are within the state of Florida, depending on what district you're in, there are causes of action for what's called spoliation of evidence. That means basically that you destroyed evidence, and we get what's called an inference directive to the jury that says you are to infer that videotape would have shown exactly what the person who wanted the tape would have shown. In other words, if the store destroys a videotape, you may be, under certain circumstances, entitled to a direction to the jury by the judge that says, ladies and gentlemen of the jury, you are to treat these events as if that videotape showed that the defendant, or in this case, the plaintiff, because you're suing them in a civil context, did nothing wrong. So it is important to try and obtain those videotapes. And they do sometimes end up missing. There are certain ways to, edit things. I've found that a lot of times these store video cameras have wrong timestamps on them. So you have to be very particular with your request and make sure that you get all that you can.
So I'd like to talk a little bit about damages, because when you sue someone for a negligent action, that is something that somebody did unintentionally. you have to prove damages. It's not just enough to show that they did something wrong. Whereas false imprisonment, detaining someone is an intentional act. So because it's intentional, you don't actually have to prove damages. It's presumed that you're damaged in the event that you're detained, just because it's traumatic, it's humiliating, and it's degrading. And that's the case even if you're detained for a very brief time. You could be detained for 1 minute and you're considered damaged. But of course, there has to be some way to measure damages, and I'm kind of curious how you do that.
Well, you do that in false imprisonment cases, much like some other cases where you talk to people about what is their emotional state, if they suffered some type of emotional damage. But I think what you were getting at is, rather than just the pecuniary damages, the monetary damages, you're looking at what would it take to stop this conduct from happening again in the future. And for that, Florida has a punitive damages statute, and Florida Section 768.72 covers that. And basically, as you said, if you are in prison for even a short period of time, and quite frankly, sometimes people are in prison for a very long time. I'm amazed at how long people have actually stayed in those rooms. I also caution people, don't give up your driver's license. They don't need your driver's license. You can show someone your driver's license. If a law enforcement officer asks for your driver's license, give it to them, but you should get it back pretty quickly. Otherwise, we all know you can't drive without your driver's license. So you have been imprisoned if they've taken your driver's license. It's, it's not a black line test, but it is pretty clear that once they take your driver's license, you're pretty close to proving your imprisonment. But you can get punitive damages, and that would be, what will it take to punish this establishment and these people from doing it again? And that's really what needs to happen in some of these cases, to deter these big box stores and their loss prevention officers from overstepping and overusing this statute.
So we're out of time. I'd like to thank my guest, Scott Zappolo. If you could tell our listeners how they can reach you.
Very simply, 561-627-5000.
Thank you so much for joining us. This is Jeff Van Treese. You've been listening to Talk Legal. Please tune in next week, Tuesday night, from 6 to 6:30, where my guest will be clinical psychologist Gina Harris, and we will be discussing the upcoming trial and insanity plea for James Holmes, the Aurora, Colorado shooting. Thank you so much, ladies and gentlemen. Have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily